Welcome to Unsolved Cases. I'm your host, Larry Hunter, and today we're diving deep into one of America's most controversial criminal trials of the 20th century. Picture this. It's 1935, and the entire nation is captivated by a courtroom drama unfolding in the small town of Flemington, New Jersey. The defendant? Bruno Richard Hauptmann, a German immigrant carpenter. The charge? The kidnapping and murder of Charles Lindbergh, Jr., the beloved baby son of America's greatest aviation hero. But here's the question that still haunts legal scholars today. Was this trial about justice, or was it about satisfying a nation's thirst for vengeance? By the end of today's episode, you'll have all the evidence to decide for yourself. If you're fascinated by chilling cold cases and infamous crimes like the Lindbergh kidnapping, the Zodiac killer, the Black Dahlia murder, and more, then Scoob is your new obsession. With bite-sized, bingeable episodes, Scoob brings spine-tingling true crime stories straight to your ears wherever you go. Step into the world of Scoob, an AI-driven podcast app packed with over 100,000 minutes of riveting content and a growing community of 50,000-plus true crime fans across the U.S. Whether you're diving into dark mysteries, exploring new leads, or revisiting old cases, Scoob's fast-paced episodes make it easy to stay hooked on the go. Download Scoob now, available on Google Play and the App Store. And don't forget to follow and subscribe to Unsolved Cases for fresh episodes uncovering the mysteries behind cold cases. Coming back to the Lindbergh case, let's start with the man leading the prosecution, David T. Wielens, a brisk and sharp Latvian immigrant known for his love of cigars, horse racing, and stylish suits. Here's what makes this remarkable. This would be the very first criminal trial Wielens would ever prosecute. How does someone with no criminal trial experience land the biggest case in America? Politics. Wielens had played a crucial role in getting Governor A. Harry Moore elected. And as a reward for his political support, he was appointed Attorney General. Talk about trial by fire, but Wielens wasn't going in unprepared. He assembled a formidable prosecution team. Anthony M. Hawk, Jr. as Special Assistant Attorney General, Joseph Lanigan, who had previously worked on the John Hughes Curtis hoax case, Robert Peacock, who had meticulously reviewed 315 documents and exhibits while verifying testimonies from 310 witnesses, and George K. Large, a former judge and president of the Hunterdon County Bar Association. On the other side stood Edward J. Riley, Hauptmann's defense attorney, who would prove to be both brilliant and, as we'll see, occasionally his own worst enemy. When Wielens rose to address the jury, he laid out a legal framework that would seal Hauptmann's fate before any evidence was even presented. He articulated a crucial legal principle. Any death occurring during the commission of a burglary is classified as first-degree murder. According to Wielens's theory, Hauptmann had illegally entered the Lindbergh residence with dual intent, to commit an assault on the child and to abduct both the child and valuable possessions. He painted a vivid and tragic picture. As Hauptmann descended his makeshift ladder with the child, the ladder collapsed under his weight, and the baby died from the initial impact during the burglary. Wielens's opening was methodical and devastating. He outlined Hauptmann's motive for monetary gain, detailed the prosecution's interpretation of the kidnapping sequence, highlighted critical discoveries at the crime scene, and described two surreptitious nocturnal encounters in the Bronx, involving the intermediary John Condon. Then came the moment that would define the entire trial. Wielens declared with firm conviction, "This state will not compromise with murder or murderers. We demand the penalty of murder in the first degree." The courtroom erupted in mild applause. Riley immediately objected, accusing the prosecution of attempting to prejudice the jury before the trial had formally begun. He even moved for a mistrial. Judge Trenchard dismissed it. The battle lines were drawn. The prosecution wasted no time calling their prime witness, the man every American knew and revered, Charles Lindbergh himself. He took the stand wearing a somewhat disheveled gray suit matched with a blue tie, but his presence commanded absolute attention. What happened next would become one of the most controversial moments in American legal history. In an impactful testimony delivered in open court, Lindbergh confidently identified Hauptmann's voice as the one he remembered hearing in a cemetery conversation with Dr. Condon over 2 years earlier. This voice identification bore enormous weight, especially coming from Lindbergh, a figure revered for his historic solo transatlantic flight. It was difficult to imagine any juror harboring doubt against the iconic Lucky Lindy. But here's where things get interesting. Let me ask you to imagine yourself in this scenario. You're sitting in a parked car on a chilly New York City night in April. From a block away, an unknown person shouts just two words, "Hey, doctor!" a voice entirely unfamiliar to you. Then, over 2 years later, after no further contact with this individual, you're asked to identify that voice. Could you do it? Would you stake someone's life on that identification? Adela Rogers Street. John, a journalist covering the trial for Hearst newspapers, noted the compelling nature of Lindbergh's testimony. She instinctively turned her gaze to the jury as Lindbergh made his identification, believing they were completely convinced. Her intuition was later confirmed through interviews with the jurors themselves. But was this identification scientifically sound? A more reliable approach would have involved having Lindbergh listen to several people behind a screen, including Hauptmann, each saying, "Hey, doc," in turn, under controlled conditions. If Lindbergh could then accurately identify which number corresponded to Cemetery John, it would lend real credibility to his identification. Instead, what actually happened was inherently suggestive. Just Hauptmann, someone already associated with the ransom money, standing before Lindbergh in the district attorney's office. The U.S. Supreme Court has since prohibited this type of one-person lineup due to its inherent unfairness. In modern legal proceedings, such a lineup would be disallowed as evidence. For Bruno Hauptmann in 1935, the law provided no such protections. One of the most critical pieces of evidence against Hauptmann was the so-called nursery note, the ransom demand left at the crime scene. But this evidence came with its own set of problems that the prosecution desperately hoped to keep quiet. Albert S. Osborne, the prosecution's key handwriting expert, made a startling admission under cross-examination. He hadn't directly compared the ransom notes against each other. Instead, he had only analyzed certain portions of the nursery note alongside samples of Hauptmann's handwriting. Defense attorney Riley pressed Osborne with a devastating question. Was such selective matching enough to justify a death sentence? The prosecution's objection prevented an answer, but the damage was done. Enter the defense's handwriting expert, who pointed out clear differences in form, pressure, and style within the letter itself. This aligned with Osborne's own earlier report from 1932, which had suggested the nursery note could have been written hastily in a moving vehicle, a detail the prosecution was extremely wary of discussing because it created serious doubt about the note's authorship. But the real bombshell was the inconsistent letter K handwriting. There were approximately 39 instances of the letter K within the ransom notes, spanning a period of 2 weeks. Not a single one resembled those written by Hauptmann in his known handwriting samples. The ransom notes showed Ks that leaned left, completely unlike Hauptmann's samples. Think about this. It would be virtually impossible for someone, even if it were Hauptmann, to consistently alter their penmanship across all letters over such a prolonged time while avoiding any characteristic slips that might reveal their true handwriting. The handwriting analysis also revealed peculiarities with the letter X. While many people from regions influenced by Teutonic culture before World War I wrote their X's in a similar manner to those found in the ransom notes, Hauptmann's X's, though bearing some resemblance, fell into different stylistic categories and wouldn't logically match if grouped together. This raised a chilling possibility. Could multiple writers have been involved in creating the nursery note? Ever wonder why some cold cases remain unsolved for decades? Join Scoob as we unravel the tangled evidence and unanswered questions behind cases like the Lindbergh kidnapping, West Memphis 3, deaths tied to JFK's assassination, and more. Explore every twist, theory, and forensic clue in Scoob's fast, captivating episodes. Crafted for true crime lovers who crave the real story behind the mystery. Download Scoob today on the App Store and Google Play. Your daily dose of suspense is just a tap away. Now, returning to the Lindbergh trial, let's explore how the defense struck back. Edward Riley knew he was fighting an uphill battle, but he had a strategy. If he couldn't secure Hauptmann's acquittal, he would try to instill reasonable doubt and push for a lesser conviction, thus sparing his client from the electric chair. When it came time to cross-examine Lindbergh, Riley pursued his questioning methodically, and he managed to corner America's hero with some awkward questions. Riley inquired whether it was possible for the ladder to be carried by one person. The ladder was segmented into 3 parts, meaning it needed to be disconnected and folded to be transported by a single person. Lindbergh gave a somewhat evasive response, stating he wasn't sure of the exact ways the ladder could be carried. Then Riley painted a vivid scenario: a muddy night with a man burdened by a ladder under one arm, carrying a child weighing about 30 pounds under the other. Was this plausible? Riley even probed about Lindbergh's engagement with underworld figures, suggesting this could have been a tactic to misdirect the investigation away from his household. With Lindbergh being a revered national hero, the defense had to tread very carefully on this sensitive territory. The questioning moved to Dr. Condon, with Riley asking whether the mastermind behind the crime might place an advertisement in the paper and subsequently respond to it himself. Lindbergh found this inconceivable from any practical viewpoint. But Riley's most dangerous line of questioning involved the John Hughes Curtis story. Lindbergh had previously testified at Curtis's trial, stating he had no reason to doubt Curtis's claims of contact with the kidnappers. Riley's questioning about this prompted visible agitation in Attorney General Weiland's. The cross-examination sought to determine if Lindbergh had believed in the involvement of multiple individuals during the Curtis trial, and only shifted his belief to target Hauptmann as the sole perpetrator after Hauptmann's capture. However, Weiland's was prepared to counter this line of questioning. Before Lindbergh could respond to Riley's implications, Weiland's insisted he be asked whom he currently believed was culpable. Left with little choice, Riley had to restate his question following the court's guidance, essentially trapped into having Lindbergh reaffirm his belief in Hauptmann's guilt. Perhaps no piece of evidence was more damaging to Hauptmann than the ladder used in the kidnapping. The prosecution claimed that Hauptmann had used a floorboard from his own attic to construct part of this makeshift ladder, evidence that seemed to create a direct link between the defendant and the crime scene. But even this evidence came with troubling inconsistencies. Corporal Joseph Wolfe, a state trooper, testified about discovering a sizable footprint embedded in the mud near ladder traces by the nursery window, estimating it to be larger than a size 9 shoe. During cross-examination, Riley highlighted that Wolfe had never taken measurements of the footprint or even determined whether it belonged to a left or right shoe. When asked if there were drag marks indicating the ladder had been dragged on the ground, Lindbergh replied that he couldn't recall seeing any such indications. This was significant because a heavy ladder being transported across muddy ground should have left clear evidence of how it was moved. Charles de Bishop, a lumberman from Massachusetts who appeared as one of the defense's last witnesses, attempted to highlight discrepancies related to the ladder, particularly regarding gaps present between the rails, further questioning the prosecution's narrative about its construction and use. The prosecution's theory required the jury to believe that Hauptmann, working alone, had carried this 3-section ladder to the Lindbergh estate, successfully climbed to the second-story nursery, retrieved a 30-pound child, and attempted to descend, all while managing not to wake anyone in the household until the ladder's tragic collapse. The prosecution's case relied heavily on witness identification, but these identifications came with serious problems that would likely be inadmissible in a modern courtroom. Joseph Perrone, a cab driver, identified Hauptmann during the trial, claiming Hauptmann had given him a note and a dollar bill on March 12, 1932. His identification came after a Bronx lineup. Yet, much like Lindbergh's voice identification, Perrone's testimony suffered from inherent suggestiveness. Even though Perrone might have had a substantial opportunity to observe Hauptmann, his inability to provide a detailed description undermined the reliability of his identification. Then there was the peculiar case of Ben Lupica, a student who had witnessed a man in a fedora driving a 1929 Dodge with New Jersey license plates near the Lindbergh residence. He testified to having seen 2 ladder sections stretched diagonally across the car's front seat. The vehicle was described as either black or dark blue, and Lupica mentioned that the man bore a likeness to Hauptmann. Here's what's interesting. Lloyd Fisher revealed that Lupica was initially slated as a state witness, but was later informed that the prosecution no longer needed him because they had more reliable witnesses. This raises questions about whether the prosecution was cherry-picking witnesses who would support their theory while discarding those who might complicate their narrative. But perhaps the most problematic witness identification came from John Condon himself. Condon's courtroom identification of Hauptmann as Cemetery John seemed to surprise even the prosecution and was deeply disappointing for the defense. Why? Because Condon had previously stated during a lineup in the Bronx that Hauptmann was definitely not Cemetery John. This assertion was made to both New York City police officers and FBI agent Leon Theroux, where Condon had firmly stated that Hauptmann was not the extortionist he had previously encountered. Yet somehow, in the charged atmosphere of the courtroom, with the entire nation watching, Condon's memory suddenly became crystal clear. Beyond the voice identification and later evidence, the prosecution presented other damaging material against Hauptmann. They highlighted his tarnished past, revealing a criminal record from Germany that included a conviction for burglary using a ladder, a striking similarity to the current case's circumstances. Betty Gow, the Scottish maid who was the last person to see the Lindbergh baby before the abduction, provided crucial testimony. During cross-examination, Riley attempted to weave an alternate narrative, insinuating that Gow, possibly acting with collaborators, namely discontented servants, had played a role in the crime. Gow categorically refuted these claims, but the stress of the accusation proved overwhelming. Her experience in court culminated in a dramatic moment when she fainted while returning to her seat. The prosecution also called upon Amandus Hochmuth, an 87-year-old local resident, who provided notably incriminating evidence. Hochmuth testified to witnessing Hauptmann driving a vehicle past his home on the day of the crime, purportedly carrying a ladder. He later identified Hauptmann in a lineup, corroborating his testimony. But here's something to consider. Eyewitness testimony from elderly witnesses, particularly involving events from months or years earlier, is notoriously unreliable. Modern psychological research has shown that memory is far more malleable and suggestible than people in 1935 understood. By February 1935, the atmosphere in Flemington had reached a fever pitch. The tension-filled air reached its climax as Willents delivered his final address to the jury. Throughout this passionate argument, Charles Lindbergh sat composedly at the prosecution's side, a silent but powerful witness to the resolution of what had become America's most gripping mystery. The American public was convinced. More critically, so was the jury in Flemington. On February 13, 1935, the day following Willents's compelling summation, Judge Trenchard delivered his charge to the jury. Using his legal right under New Jersey law at the time, he offered commentary on the evidence that effectively eliminated any possibility for an acquittal. By 10:22 a.m., after an exhausting 32-day trial featuring over 90 witnesses and testimony amounting to more than 1 million words, the jury took only 11 hours and 21 minutes to deliver their verdict. Guilty. When the verdict was announced, it sent waves of excitement through the courtroom, the crowds gathered outside, and across all of America. Later revelations would show just how predetermined this outcome had been. When the jury first convened, guided by their foreman, Charles Walton Sr., who had remained neutral until the trial concluded, they promptly voted for a guilty decision. Most of their remaining deliberation time was spent considering the faint murmurs advocating leniency for the accused. Ultimately, they chose not to extend any mercy. While the courtroom erupted in celebration, Charles Lindbergh was at Next Day Hill with his wife Anne and her mother when the radio announced the jury's decision. Also present was English writer Harold Nicolson, who was residing at the Morrow home to work on a biography of Ambassador Morrow. The broadcast emphasized that Hauptmann had received the death penalty rather than life imprisonment. Nicholson recorded in his diaries how the atmosphere shifted to complete silence, moments after the news aired. In the ensuing quiet, something remarkable happened. Lindbergh began to meticulously recount to Nicholson the evidence that had led to the guilty verdict. Though Nicholson was already well-versed in the evidence, he found himself puzzled by Lindbergh's detailed review. But then Nicholson noticed something telling. Anne and her mother appeared deeply troubled, their expressions marked by uncertainty. It dawned on him that Lindbergh's recounting of the evidence, while seemingly directed at him, was actually intended to reassure Anne and her mother. Lindbergh delivered the summary with a persuasive tone meant to instill conviction in his family members. Most notably, Nicholson observed that Lindbergh never actually declared Hauptmann guilty. Instead, he consistently reinforced that the evidence was overwhelming, leaving the inference of guilt unspoken but implied. Even America's hero seemed to need to convince himself. Just when most Americans thought the case was closed, an unexpected champion emerged for Bruno Hauptmann, Governor Harold G. Hoffman of New Jersey. Through his thorough investigation into the case, Governor Hoffman developed a firm belief that Hauptmann had been the victim of an unfair trial. His earnest attempts to have David T. Willents removed from his position as Attorney General bore no fruit, but his efforts eventually led to the ousting of Colonel H. Norman Schwarzkopf, from his role as head of the New Jersey State Police. Critics immediately accused Hauptmann of political grandstanding, pointing out that both Wilens and Schwarzkopf were aligned with parties opposite to his own. They suggested he was using the case as a platform for public showboating. But such criticisms overlooked the depth of Hauptmann's convictions and the personal cost of his stance. Although a small but growing faction of skeptics was beginning to question Hauptmann's guilt, the overwhelming majority of the populace continued to support the trial's verdict. Charles Lindbergh, whose child had been kidnapped and murdered, retained immense public favor and sympathy. These political dynamics had a discernible impact on Hauptmann's career, likely contributing to his failure to secure re-election. Yet his passion for the case outlasted his political tenure. Even after leaving office, Hauptmann remained steadfast in his belief that Hauptmann's trial was marred with discrepancies and that the evidence used against him was insufficient and possibly manipulated. Hauptmann shared that his frequent interactions with Hauptmann in prison left him deeply moved by Hauptmann's sincere proclamations of innocence. Additionally, Anna Hauptmann, Bruno's wife, exhibited unwavering devotion, pleading fervently for her husband's innocence. Governor Hauptmann's investigation wasn't just theoretical, he took direct action. Despite knowing the prevailing public sentiment supported Hauptmann's conviction and death sentence, he pursued what he believed was the truth. Hauptmann arranged a private meeting at the Hauptmann residence with the key figures who had built the case: Wilens, Schwarzkopf, Detective Bornman, and Arthur Köhler, an expert witness at the trial. His purpose was audacious: to challenge them to substantiate their claim that Rail 16, a crucial piece of evidence, had actually originated from Hauptmann's attic. When they were unable to definitively prove this connection, Hauptmann made a shocking accusation. He boldly accused them of fabricating evidence. On December 5, 1935, showing immense resolve, Hauptmann publicly declared his intention to approach the New Jersey Board of Pardons and advocate for Hauptmann's execution sentence to be commuted to life imprisonment, regardless of any pending Supreme Court decision. The reaction was swift and telling. Just 2 days after Hauptmann's announcement, Charles Lindbergh instructed his wife Anne to prepare for a potential quick departure to Europe, asking her to have their belongings ready within a day's notice. Despite Anne's conflicted feelings about leaving their homeland, Lindbergh's resolve was unwavering. The family that had become the symbol of American tragedy was preparing to flee the country rather than face continued scrutiny of the case that had made them famous. Still haunted by the mysteries that never got solved? Step into the shadows with Scoob, the podcast platform that digs into chilling cold cases and the questions that still don't have answers. From infamous crimes that grip the nation to lesser-known cases that demand a second look, Scoob brings you tightly packed, binge-worthy episodes made for true crime fanatics. Join thousands of listeners committed to keeping these stories alive. No fluff, no distractions, just gripping, mysterious cases. Anytime, anywhere. Follow and subscribe on Scoob to never miss an update, including chilling unsolved cases still waiting for answers. Download now on the App Store and Google Play. As we reach the end of our journey through the Lindbergh trial, we're left with more questions than answers. Was Bruno Richard Hauptmann guilty of kidnapping and murdering Charles Lindbergh Jr.? The jury thought so. The American public believed it. But was their conviction based on solid evidence or on a desperate need for closure in a case that had traumatized the nation? Consider the evidence we've examined today. A voice identification made over 2 years after hearing just 2 words from a block away. Handwriting analysis that showed clear inconsistencies within the ransom notes themselves. Witness identifications that would be inadmissible in modern courts due to their suggestive nature. A ladder theory that required believing one man could accomplish an incredibly complex crime while leaving virtually no conclusive physical evidence. And then there's the aftermath. A governor who risked his political career because he believed an innocent man was about to be executed. A hero aviator who felt compelled to convince his own family that justice had been served. A case so controversial that it drove the Lindbergh family to leave America permanently. Perhaps the most troubling aspect of this case isn't whether Hauptmann was guilty or innocent. It's whether he received a fair trial. In the atmosphere of 1935, with public hysteria reaching fever pitch and an entire nation demanding vengeance for the crime against America's most beloved family, could any defendant have received true justice? The Lindbergh trial stands as a stark reminder that even in our system of justice, the line between legal procedure and mob justice can become dangerously thin when public passion overwhelms legal prudence. Bruno Richard Hauptmann was executed on April 3, 1936. To his final breath, he maintained his innocence. The truth? That's something each of us must decide for ourselves. Thank you for joining me for this examination of one of America's most controversial trials. If you enjoyed today's episode, please subscribe and share your thoughts. Did justice prevail in Flemington, or did public hysteria claim an innocent man? The debate continues to this day. Until next time, this has been Unsolved Cases.